You may please.
Yes, my lord, restoration application, my lord.
On review application, the order was passed by Honorable Justice Holy Standard Appeal Lordship hearing on the Lay Lordship. Now, my lord, as per your Lordship convenience, the bench is concluded for hearing the review application.
Mention in the next week. You mentioned.
Sir, item number 1.
My lord, I beg to appear on behalf of respondent, my lord. As being directed by my lord, we have sought instruction from the department, my lord, that the Patna High Court judgment. My lord, that orders is of Jal Shakti under Central Water Commission, Ministry of Jal Shakti, my lord. Now we had sought instruction from them, my lord, they do not have the file. Now nodal agency is Ministry, Department of Finance, my lord. So my instruction is to pray before my lord to seek 3 months time, my lord.
3 months.
My lord, these are the instructions. Kindly allow me to speak. Why you always come between the? I fail to understand. My lord, this is the sorry, my lord.
There are 2 judgments in our favor.
My lord may kindly takes paragraph 6, my lord. They have given the reason why this time is being short for, my lord.
Judgments are in our favor.
My lord. Can't make out what they are trying to say in paragraph 6.
My lord, the basic instruction I have talked to them. After I received this instruction, my lord, I have called them.
Yes,
So
give it back.
My lord, this the Patna High Court judgment relates to my lord.
Yes.
Jal Shakti Mantralaya, my lord. And
Yes.
that file since 2014 matter, that file is not with that list. Now the nodal authority who submits all the finance is Department of Finance, my lord. What they told me. It has to come from Department of Finance. It has to through Department of Jal Shakti Mantralaya, my lord. What they have said. So it will take that because they have already made a writing that what is the outcome, whether it is prepared or you have implemented the order. This one.
We have produced a document that we have they have implemented the order. We
My
have
lord,
produced
this is
a
the
supplementary
official.
affidavit.
This is the official
You
position.
think we will proceed without allowing you to make any submission? Or you think interjection will help you a lot? If you think either of the two, you may continue in this way. Yes.
So, my lord, already written instruction they have already made a official communication that what is the outcome, whether any appeal implemented. So, officially they said that now it is Ministry of Finance.
All right. Now we have understood what you are saying. Let us
This is
see.
the difficulty, my lord.
And what have you got instruction about implementation of that judgment?
Filed a supplementary affidavit stating that the order has been implemented.
Where is that supplementary affidavit?
This is on 23rd July we have filed the supplementary.
Which paragraph you have stated? Which paragraph you have?
Implemented, we have annexed the 13th February 2017 order, notification. We have annexed it.
What is the date of the order by the Patna High Court?
Page 526.
What is the date? Just give us the date.
Date of the Patna High Court order is Patna High Court order is in 523 page number
It is CWJC 8459.
459 of 2014. Date is 17/3/2016. And we have also received the RTI information that the order has been implemented.
This is a direction to implement. It is not that it has been implemented. What has happened after this? That is why on the last occasion we asked him. We had seen this. This is a direction to the executive engineer, but then the compliance
They
report.
have to file the compliance report.
So where is that? Have you said that after that in the supplementary? That's why we are asking. Where have you said? Let us see.
They are receiving the payment. For a great pay of force, he is receiving. This is the implementation order. I have.
Let us see.
It is in Hindi. That's the issue with me. আরেকটা copy আছে আপনার কাছে we have done RTI to it.
Brought on record. They don't have. 17/3/2007 CWJC. Case number is not there. That judgment is Om Prakash Singh. Om Prakash Sinha.
Yes. Om Prakash Singh.
You give him a copy. You place this on record, give him a copy. We'll take it up in the next week.
It's in Hindi, so I can't understand.
Get a translated copy. Get a translation done. The learned. By when you will file it? Tuesday? List on 22nd?
22nd.
Yes.
Let it 22nd, let it be on 21st.
No, 22nd.
I have a matter.
Then 20th.
28th.
20. Yes.
20. My lord, 20 I will not be there, my lord. Kindly make it on 21st, 22nd, any day, my lord. I will be, my lord, outside, out of station, my lord. I will return on 20th, my lord.
25th.
Get to the-
I'm deeply obliged.
Item number 2.
Milord, this is, I'm sorry, Milord. I'm tendering my unqualified apology, Milord, for not being able to present myself before your Lordship, Milord, today. Milord, this is a matter that kindly, Milord, recalls that the appointment that was made way back in 29 January 2044 after a long-standing passionate curial combat, Milord, started its journey from 1998 and ended in High Court in 29 January 2014. Milord, we were given an appointment, Milord, by the Railway Authority, and the essence of the direction passed by the High Court, Milord, way back in January 29, 2014, that our appointment shall be governed by, Milord, the recruitments as that was prevailing in the year 1997, although the appointments made in 2014. Be that as it may, Milord, we accepted the appointment, and the appointment was issued in the month of 2014 March, Milord, and we are continuing with our service, Milord, with with unblemished career record. Now, Milord, be that as it may, after disposal of the first round of litigation, Milord, we approached the Railway Authority that since it was not our choice or out of volition that we were sitting on the fence and did not join the service, because it was your fault. Fault is attributable to the Railway Authority, by reason of which, Milord, we were denied appointment. So we are not praying for any, Milord, arreared salary for the services which we did not render. We said, Milord, the notional fixation of pension, Milord, so that the juniors, Milord, who were subsequently appointed by the Railway Authority by virtue of an ex-selection process, as that was conducted way back in 1998, that so that there must be a parity, as well as, Milord, our deprivation, Milord, the Reed Court can grant, Milord, the restitutory and compensatory relief both. So on that score, Milord, believing on that legal proposition, we made an application for the representation to the authority. Authority said nothing doing, you are not entitled to. Milord, intervening period, Milord, during the pendency of the writ petition, Milord, we came across, Milord, with the, Milord, the pensionary benefit, Milord, under the old pension scheme, and we were allowed to switch over from NPS to OPS. Be that as it may, during the pendency of the writ application, Milord, suddenly, Milord, we were slapped with a notice that, Milord, 17 May 2024, possibly, Milord, the petition is not with me. I placed it before your Lordship, that the Railway Authority, Milord, had contemplated, Milord, to withhold, Milord, the entire benefit that was conferred upon us. It is the railway stand, Milord, on the last day, Milord, as reported by my learned junior to me, that this is a mistake on the part of the Railway Authority. Although they did not cancel it, Milord, but they have decided to withhold because of the pendency of the litigation. Milord, my respectful submission and understanding of law before your Lordship, subject to what my lords will say, that any executive policy subsequently taken, Milord, that cannot curtail, Milord, the accrued right under any circumstances, Milord. So I would beseech your Lordship, Milord, that to consider this, and because in a supplementary affidavit that was directed to be filed by us, we have narrated, Milord, our position, our promotional avenue, the notional benefit if not given, then what is the amount of pension, Milord, what is the financial loss that will be meted out to us, Milord, and for no fault of our own. And whether I am entitled to make a submission before the highest constitutional court of the state, Milord, that the Railway Authority, being an authority under Article 12 and a role model employer, whether it can, Milord, claim privilege of its own responsibility. Because they first took a stand, Milord. If your Lordship kindly goes through the record, your Lordship will be pleased to find that the Railway Authority had made a stand that because of the entire office of the Railway Authority, where the records were kept, Milord, that were set ablaze. And accordingly, Milord, it was not possible for, Milord, the authority to grant appointment. It is because of the High Court and its generous and, Milord, courageous endeavor of the Constitutional Court, Milord, the records were traced out, and ultimately, Milord, Milord, the unemployed youth were blessed with the appointment, Milord, by the Railway Authority, and that is because of the High Court heavily came down upon them. Be that as it may, that is a past, but we cannot forget history, Milord, for all the times, Milord. So that is why I respectfully submit before your Lordship, Milord, that kindly, Milord, have the charity to consider this particular aspect, not a arrears salary, but a notional benefit to be conferred upon us. And this prayer seems, it is not possibly, Milord, not unreasonable, my lord, and not beyond the scope of law. I beseech your lordship and leave it to your lordship's wisdom and kindness.
Very well.
Today they are supposed to file the paper book.
We have given.
They have
Yes,
filed. My lord, there was a difficulty, my lord, your lordship may know, in course of hearing, the page is referred. My lord, today, yes, sir, my lord, I have got it today morning itself.
My lord, we have filed it. My junior, my lord, Mr. Dey is here.
Saturday, my lord, we have.
Yesterday at 5 p.m. it was given to, by that time I left the court, my lord, it was given to us.
Just imagine our difficulty unless we mark the pages.
Yes,
The
my
way
that
the
has to
brief,
be done by me, my lord, also.
the way the brief is with us, it will be impossible once you.
Yes, yes, my lord, I tender my apology. If my junior commits any mistake, it is my responsibility. I
No,
cannot
it's
shove
not a
up my
mistake. We have
No, I
already,
have to-
we have
I have
already
to
asked
tally
him to
the
give the
pages.
paper book for convenience sake. We just wanted that if it could be tallied with
Hey,
the
my lord,
pages.
kindly give a chance, my lord. Today, my lord, I am also not with the paper book. I submitted everything from my memory, my lord. My memory sometimes betrays me.
Just allow you to point out where you have referred
Yes,
so that
yes.
we can mark it in the paper
Yes,
book.
yes,
In
my
the
lord.
meantime,
Kindly give me a chance. Kindly give me a chance, my lord.
that is what
I
we are
tender my
proposing
apology.
to do if you allow us.
I'm sorry. I'm sorry. I tender my
If you
apology.
allow us, that is what we are proposing to
I'm
do.
sorry, my lord. I'm sorry.
Yes. So when can we have it?
20th on Wednesday.
21st,
Tell us
20, no,
date.
21st,
You please agree to a date, both of you.
21st and 22nd, any day.
Thursday may not be possible because Thursday we are
Friday,
not
my lord,
taking up hearing
22nd.
matters.
I'm sorry, my lord, 22nd,
20th, 20.
22nd or the
22nd,
week thereafter. What is
22nd,
Possible.
20.
20th,
So next
20th,
Wednesday.
no 20th can't be.
Next Wednesday.
20th,
22nd, 25th. What do you want? Tell us.
22nd, yes, 22nd possible and 25th. Give me a 1 second chance.
22nd,
One
my lord, I
second.
have difficulty, my lord.
Now 22nd, your
I
junior
have
has difficulty. Then
Sir,
25th.
I have
What is
difficulty
the
on
between the
22nd.
juniors and the seniors?
25th, my lord.
Yes, Mr. Basu. 25th.
Yes, Millard, 25th. I'm deeply obliged. 25th.
As joint
25th. I'm extremely grateful, Millard, for your lordship's generosity, Millard.
অর্ডারটা হয়নি এখন। 25th, informal paper.
Well, at the outset, I beg apology because in earlier occasions, I took your lordship's time and there were certain discrepancies because
We
of.
don't remember anything. Once we
My lord,
go from this
that's why, my
dais,
lord,
we
I'm
forget
facing-
everything.
My lord, the question is, my lord, it is relating to the promotion and a notification was issued. My lord, lordship kindly take up the way at page 25, P1. That is the first annexure. No, no, next second. My lord, the way annexure of the way filed before the tribunal is at page 26.
26 of
The way. That is annexed, my lord. There is maybe some discrepancy.
just a minute.
Yes.
Just.
That is as page 25, 26. I am sorry, my lord. This was the notification for limited departmental examination for promotion to the post of assistant.
Just wait, please. Please wait.
I am sorry. Which is like 28 touch.
No, refresh the facts first. Give us the facts. We don't remember. What is the facts? The exam was, there was an exam.
Yes, this notification, your lordship has seen, my lord. This notification, in terms of this notification, my lord, the initial date of examination was scheduled, my lord, notice for promotion to the initial written examination, because this consists of two papers, paper 1 and paper 2.
Yes.
So this initial date for written examination was scheduled at 8th of January 2016. Lordship will find from page 28.
What is the date of the notice?
Notice 25th of January 2016. And prior to that, my lord, 2027. Lordship, kindly see. Express his willingness.
At which page, sir? Can you give us a page, please? At which page we are to find this document?
My lord, the page 28, P3 of the OA.
Page 23 of OA. There is no
28.
paging. There is no paging of OA. Page
No,
23.
the annexure, lord. OA is not paginated. The annexure attached to the OA has been paginated.
You file a paper book. What can we? We can't locate anything. Letter inform. Give him date. Tell him.
Sir.
Tell him that.
Huh?
Service. Item 4. I appear for the respondents. On the to tag other matters. Here we but here we not.
No, before that, notice is directed for produce policy decision.
Yes.
Kindly see the order.
I am coming. I have completed my
No.
Not same time, you also directly to use the policy, regarding the compassionate appointment at the relevant time.
That is 22/1/2003.
So here, my lord, that is, what happened? The appointment was made in 2003, GDS. Then, my lord, came, my lord, the advocate later was saying, but claiming for the postal assistant. And then, OA was filed. So, OA was decided. OA was decided on.
One minute, my lord. Notice directions was to file supplementary affidavit. And first direction on the previous day we missed it. By Justice, presided over by Justice Topobroto Chakraborty, directed to file supplementary application, annexing the writ petition.
Copy has been given to you, that is related.
Yes. Take it. Supplementary affidavit.
Next matter, this one.
Supplementary affidavit is taken on record.
This supplementary affidavit, the readings relied on by the reporting. Other case.
Other case.
So kindly have a look, note, on page 43 of this supplementary. 43 is the judgment. Lord, judgment passed in 8/1/2011 along with the other two matters. Here, my lord, this judgment, the policy has been
46 to 47.
43 years.
So you have not got the policy.
See here,
It is noted here.
it has policy. Page 2, that is the 44, page 44. 44 is the policy.
কেন রে? হ্যাঁ?
162. 6162.
In the next plan is also connected with that GDS point.
এর ওটা পি কত? জাজমেন্ট অর্ডারে আছে।
Earlier approved candidates were kept in waiting list. That was abolished. In paragraph 3.
61 there. কেন আছে? কোনটা? আপনার চার
In paragraph 7 of the judgment, Lord, paragraph 7 of judgment, it speaks about, Lord, that the appointment given to the applicant as GTS shall be deemed to be in accordance with law. Said that time that RTI they made and they found there
When
was
we are reading, if you are saying something, can we understand anything? Neither we can read nor we can hear you. Does it serve any purpose? Why do you do like this? We don't know. Yes. This was passed in the case of the petitioner.
first case.
So thereafter, they have again approached you.
Then they said, then by RTI, they have come to know that there were vacancies. Then, my lord, the court directed, paragraph 7.
All right. Just now, you please wait. Yes. These two petitioners are in these two writ petitions.
Fine.
So after this, what happened? After this, what happened?
Thereafter, my lord, that the appointment, we made representation.
First, show us your appointment. Where is your appointment?
E1, my lord.
E1.
E1.
Page 35, my lord.
Page 35.
Page 35.
Please. Yes.
My lord. Page 32. In the repetition of 246 or 247, lordships. Lordship's hand is 246 or 247.
Which is the first case, sir?
247 is the first case. Case 33, my lord.
Page 33 is a table. Page 33 of what you are referring? Supplementary.
No. Main.
35. Supplementary.
My case has been approved for postal assistant.
We are asking you, where is your appointment order?
Case 33 হচ্ছে কি? required. That is T8 for page 42. Firstly, we denied to take this appointment. Thereafter, they said that your claim will be forfeited. Then we said we are accepting, but if postal assistant post is vacant, then kindly give us the appointment in postal assistant.
So what have you done after the order passed in OA? Now show us. After the first OA was disposed of, what happened?
My lord, thereafter, my lord, we have made some RTI, and from that, my lord, we came to know that there are some vacancies at the relevant point of time in 2002, 2003. My lord, that's why we made a representation.
Where is it? Show us.
In my representation, it is categorically stated in which year, that is in that representation, my lord, is it starts from page 77. But it starts from page 77.
Age?
Our presentation starts from page 77. Page 81 is the relevant. After making this representation, we file another application before the
You were claiming appointment in which year?
2002, 2003. They have given me appointment. We made application on 1998 and 2098 we have made application. 2002 we have been selected as PA, but appointment was given in the year 2003
As GDS.
as GDS. And we have obtaken under threat that our name will be struck down if you did not take this.
Yes.
So we take it. Thereafter we made representation. And my point is, my lord, we made representation and filed an application before the Central Administrative Tribunal, where the tribunal asked for giving us for consider our representation. But my lord, while they have considered, they have not given us any opportunity of hearing. That is violation of principle of natural justice.
Very good. Yes.
So if we got a chance for an opportunity of hearing before the concerned authority, then we can prove our case. But in the last order, it has been denied and rejected our claim.
So after the tribunals, the second way you filed.
Second way. And in the second way,
After second way, what has happened?
the order lordship kindly see page 84.
It is 17/9/2018. What is the date of the order? 17/9/2018.
No, 8 June 2018, the tribunal passed order.
After the tribunal, the authority has passed the order on 17/9/2018.
17/9/2018.
Yes.
Challenging that we filed. No, after that order, my lord, we filed in another way. That is also kindly come to page 84.
Second way we have already seen. How many times you will show us the second way?
Three original application.
Where is the third way?
Third way is last one. Lordship kindly see page 84.
No, third way is the present one.
Yes. Yes. Second way order lordship kindly see page 84. On the basis of which the authority passed order without giving us any opportunity of hearing. And on the basis of the said order, the impugned orders, the order passed by the authority on 17th September 2018. And before passing this order, no opportunity of hearing was given to us, so that we can prove our case that there was the vacancy. There was vacancy. And that has not been considered by the tribunal.
Under which communication this detail was supplied to you? Give the detail.
RTI.
Yes. From your representation, show us which communication disclosed this vacancy position that you have stated in your. Yes.
কথা বলবি না বিনা কিছু কথা বলবি না One minute. It starts from page 57. It starts from page 57.
We are asking you in your representation, which communication you have relied upon to sustain the number of vacancies you have claimed in the representation. Show us from your representation.
My-
You say that 2 vacancies were
Yes,
there
yes.
in 2002. You say in 2003 it became 4, all remained vacant. So in the representation, you have given this detail, but it is based on which communication from the authority? Show us.
Well, it starts from page 77, our representation, and it is page 81.
Yes, which communication? Give us the detail.
It is 14th March.
Again, we are asking you for the third time.
14th March 2017.
We are asking you that you have specified X number of vacancies. You say, I have been informed that this X number of vacancy exists. That information you have received by which communication? In your representation, where have you stated that RTI reply on such and such date has disclosed this vacancy position? There's nothing.
It starts from page 79, last paragraph. That my client in his base report started collecting data regarding availability of vacancies for filling up the.
It starts from 79, goes to 81. We have read that. Again, we are asking you, where is the communication which informed you that there are 2 and 4 vacancies existing in 2002 and 2003?
Communication. It starts from page 57.
Representation. From your representation. That is what the authority has considered. Show us. The authority's decision is on your representation. In your representation, where you have stated that by communication dated so and so, I have come to know that there were 2 vacancies in 2002 and the vacancies became 4 in 2003.
That is page 80, my lord.
Point out which communication.
That ultimately almost 1 to 3, paragraph 3.
Yes.
That ultimately almost all the postal division except Q1 replied thereby supplied information as for whether any vacancy under exempted category was lying in the year 2000 to 2003, which was the relevant and material, as at that point of time my client was selected for the post of postal assistant and his selection was also approved by the authority concerned under dying in harness category, as my client's name was approved in the year 2002 and he was compelled to accept the post of GTS at the material point of time that any vacancy was available or not. That information was necessary for consideration of the case of my client as per direction of the Honorable Administrative Tribunal. That from the information supplied by the Department of Postal Division of the West Bengal Circle, it is absolutely clear that at the relevant point of time there was.
Which information? Of which date? Which memo number? Again, we are asking you.
That clearly I have not stated, but
So, there is no assertion
so,
that.
my lord, page 81,
All
my lord, we have given the.
Yes,
data.
you, therefore you could have said 8 also. Why only 4? Why you have said only 4 in 2003? You could have said 8. If it is not to be based on any communication, then you can say 5, 4, 3, whatever you want. That's why we asked you, where is the disclosure based on which you have approached them? Nothing. In your representation, there is nothing.
The representation, my lord, the lordship is correct. That
Then that is what they have decided.
but lordship kindly see.
That is what they have decided.
That lordship kindly see page 81. If your lordship asks me, I can.
We are not going to ask you.
No, I cannot improve that.
Therefore, we gave you the opportunity, whether it is there or not. If it is not there, what can be done?
But lordship kindly see, we have already
That we will consider. 2002, 3, you are that we will consider.
that
Page 81, we will consider. Don't worry.
81, 82,
Yes, yes. Everything.
and 83 may be considered.
All right. That's all. Yes, come, take down. difference.
The issue is, my lord, common judgment has been delivered, just number is different. I am giving the number.
No, there will be confusion. Just show us where is the decision, disposal of representation is by which
The previous,
which order?
previous
17/9/2018
14
same.
March.
Yes. There is no distinction. The representation also contains the same.
Same. The origin, the number of OA is different. In this case, Gopal Chandra is OA number 819.
So it can be by a common order also.
This order is common order. In all cases, common order has been passed, excepting the second one. Second one was individual application on the self-same issue.
Second one means
Second OA application filed by the against the challenging the reason order passed by the authority, my lord. Passed by the authority against the reason order passed by authority. That is page 91.
in the first case, it was what was the number of the second OA?
81819 is the first OA application.
So where we have said OA number 819.
819. When we come to page 57 of the supplementary affidavit submitted by learned friend Malar, is a common judgment passed by the tribunal containing 3 OA numbers.
Second OA, what is the number of the second OA in the first case?
Case is second OA number.
Yes.
My case 350.
819 is the first OA. Instead of 820, 819. अभी बताया ना, instead of 820, 819. अभी तो लिखा है ना वो
అది అనాథాల డేటా రిజిస్టర్
Item 6.
ఓకే
Not today. Item 7. Item 7.
I'm for the respondent, my lord. No, in this matter, I am for the respondents.
Wait.
My lord, 7 to 11, the same matter.
One by one, let him come. Same order. Item 9. All are same order. Item 10.
Same.
None appears. Same order. 11.
Same. My lord, may I humbly submit that, my lord, these matters are pending for a couple of months. Every time, my lord, they are taking the time and that's
Every
why
time.
they pending-
Today is the first time it has come. Earlier it was listed only once.
No, my lord, it is pending in the list. At least it was, I have seen at least it was adjourned by your lordship. But
You
Right.
please see, there is only one order before today. We don't know how you are saying. We will rely on our order sheet. There is only one order before today.
now, my lord, I humbly pray that your lordship will kindly fix a date so that
What fix a date? After 3 weeks it will come. If they are not interested, what is?
over adjournment হয়েছে তো দেখে দিবে। Okay.
Item 12.
Only adjourn.
Respondent, my lord. You allow me to file the repeated opposition, my
What are you filing?
opposition, my lord.
You have served.
Yes. They will file the reply also, my lord.
Petitioner, my lord.
Hmm?
Mr. Monish Kumar Das is appearing for the petitioner, my lord. But he could not come to court, my lord. Kindly make it not today, my lord.
You have served a
Similar-
copy.
Yes, my lord. We received the reply also, my lord.
They have filed a reply.
Yes, yes, my
There is no reply. Where is the reply?
lord.
Similar matter, my lord, has been adjourned on the ground that
Similar
Lord.
matter has been dismissed.
minor.
Other of my lord's order, they are already dismissed.
What is it?
Similar matter, my lord. My lord's order, my Sorry, my lord, only we have matters. It's a similar matter.
Finally, make it not
Again,
today, my lord. Mr. Das will appear.
And this
Done.
and
One time it must have. Yes.
My lord, kindly take it on tomorrow, my lord. He will appear. Mr. Das will appear.
Not today.
today,
Position is taken on record. Opposition is taken on record. Return that copy.
Case number
opposition has been filed by today. Today, opposition and record.
Position taken. Not.
And 13.
My lord, in item number 13, I am led by Mr. Dheeraj Trivedi, senior advocate. My lord, he is not there for this week, entire week, my lord. If the matter can be postponed to the next week, my lord.
My lord, I will humbly pray that the matter may be taken up after 25th, my lord.
So give us a date, agreed date.
My lord. My lord, check.
5th September. 5th September is a holiday.
No problem. Anytime.
Why 5th September?
3rd September, my lord.
An adjournment is sought for.
That's 14.
I pay for the petitioner. My lord, in compliance of your lordship's direction, my lord, passed my lord, on 29 July. I have served notice, my learned advocate appearing for the respondents. Notice, sir. So, study. Lord, this is challenge.
Why you are giving only one?
Oh,
Who has received it?
my lord, she's Rumina Shamin.
No, it is on behalf of. It's not received by her. Who can receive on behalf?
I had a talk with over phone with her. Yes, I understand, my lord. Maybe his clerk, my lord. My clerk, my lord.
So you have to say who it is.
But the name is there, my lord. Rumina Shahin. Rumana Shahin.
But
The clerk, well, that I do.
who has received?
I sent my, clerk to.
But that the learned lawyer has not received. Somebody has received on behalf of. We don't know who this person is. You will have to tell us.
Normally, this is our practice, my lord. We send our clerk to serve upon the learned advocate, and the learned advocate's clerk will acknowledge that.
But then normally we have also seen it. They say AC2. They must say AC2. Advocate's clerk to Ms. So and so. But that is not there. So who is this person? We are at a loss. Either you clarify.
No, I cannot clarify because I personally did not go to serve. I cannot.
Then what is to be done? You tell us. What should be done? How we can accept this?
I'll serve again. What can
You do it once more. You let us.
I said I have to serve again, my lord.
Yes, the learned advocate
Unfortunately, my learned friend is appearing. But I said that order is passed, nothing can be done. Unfortunately, sir, after the order is passed, that is last.
No problem. We have fixed it.
15.
Your Lordship, in this matter, Mr. Shorijit Shamanto is here, senior advocate, and since he is in SAT, in Honorable SAT, so therefore he'll not be able to attend the court. So therefore,
Not today. You will not today.
I mean, not this week, Your Lordship, if Your Lordship. No.
Christian.
To the church.
Yes, ma'am. 1/6. But this matter, my lord, pertains to, my lord, the retired employees, my lord, denial of giving, my lord, the MACP benefit on the ground of pendency of the criminal case. My lord, my lord, initially joined, and after that, my lord, after expiry of 30 years of my service, I was granted with the MACP in 2012.
You were granted
Yes, I was granted.
in 20. No, you retired when?
I retired in 2014.
Yes. Prior to retirement, you got ACP benefit in 2012.
MACP benefit, third MACP.
Third MACP. Yes.
In 2012, my lord, I have got.
Then?
That would be, my lord, 19th April 2012.
Yes. Then?
Yes. So, my lord, in this meantime, my lord, I was, there was an FIR that was initiated against me under section.
In the meantime means after 12.
No, before that. 12.
Okay.
Which is in, my lord, 2009. But there was an FIR that was, my lord, initiated against me under section 420, 406, etc. My lord,
Not relating to service.
not relating to service, my lord, with
So you were accused in some case.
Yes.
They came to know about this.
Yes. I was arrested.
Oh, okay.
And I was arrested.
Suspension, then revocation of suspension.
So when I was suspended, and thereafter that was revoked. And that was, my lord, revoked back in 2010. So be that.
How long you were under suspension?
My lord, I was in the suspension, my lord, tell your lordship. My lord, from 11th January 2010.
Yes.
Sorry, with effect from 9th of December 2009.
Yes.
Up to, my lord, 9th of December 2000. My lord, up to, my lord, 16th of November 2010.
1610.
Yes.
2010.
November 2010. I was in suspension for this time.
So you were in custody for this long?
No. I was in custody for 1 month, but I was in suspension for this time.
So they decided to continue the suspension even after you were
revoked. So for the documents that I have found, my lord, that it is revoked in that particular date.
16/10/10.
Yes, 16/11/2010. 16th November 2010.
Yes.
My lord, thereafter, my lord, I was granted with the MACP benefit, my lord, in 19th of April 2012.
Yes, that you have told us.
So thereafter, my lord, I was retired from the service in 2014, June. And after
31st June.
30th June.
30th June.
And after that, my lord, I should, my lord, mention that in spite of granting the MACP benefit, my grade pay was not increased.
So only an order was issued,
Only an order was
not given effect to.
not given effect. So thereafter, my lord, after the retirement, I went on writing to them that issue the MACP and also the full pension, because provisional pension was being paid to me because of the pendency of the criminal case. So my lord, they issue an office order by saying that you will not be given with the MACP benefit and the other pensionary full benefits since the criminal case is pending. If the criminal case ends, then you will be given with that. So that was one of the office orders. After that, my lord, I once again, my lord, started writing to them that under which provision can you withhold my MACP benefit. So, my lord, thereafter, my lord, in 2016, my lord, they issued an office order in 18th of April 2016, by which they deleted. They said that you were wrongly given with the MACP benefit. It is hereby deleted. So thereafter, my lord, I challenged these, my lord, in the original application. My lord, the original application was dismissed on the ground that since there is a criminal case pending, he was wrongly given with the MACP benefit. So rightly, this MACP benefit was deleted. That was the ground on which the learned tribunal dismissed my application.
So let us see the MACP. What does it contemplate? Whether it can be granted.
So, my lord, I was also trying to check upon whether there was any provision which entitles the employer to not to give MACP if there is.
So there are two aspects now. One is MACP and the other is full pension.
Yes, my lord, but I'll be just visiting a lordship only with respect to the MACP, because the full pension part, my lord, they say that they are paying the full pension.
All right. So we are only concerned for the present with the MACP.
Kindly, because the dismissal of that also, my lord, on that particular ground. My lord, if I request your lordship, my lord, I subject to correction
So
of my
before the tribunal, have you stated why, under which
My
provision?
lord, I have been led by Mr. Aurobindo Sen. My lord, we have not received any instruction from the department.
So what instruction? You must have filed a
I
reply.
have been led by sir, my lord. I need
There
to
is a
check
reply on
instruction.
record.
Yes.
The reply filed by you before the tribunal, it must be on record. Therefore, instruction is not required. We'll confine to the pleadings. There's nothing new can be introduced now.
So, my lord, if I request your lordship, my lord, to see, but I could not find out anything except 18.
Normally, it says that other eligibility for promotion you should possess. So,
lordship kindly sees that. Once, my lord, page is 18, my lord.
My lord, reply was filed on behalf of the respondents before the central tribunal. Yes.
So therefore, that is there. That your stand is already there on record.
Yes, we have the copy.
My lord, may I place, my lord, 18?
Rules governing normal promotion.
Lordship. So this
That
is
is,
why I come here, my lord.
In some time-bound schemes, it is missing, but in some it is incorporated. Here it is incorporated.
So it is said that in the matter of disciplinary or penalty proceeding, well, I at first will be reserving my submission with respect to the fact that this criminal proceeding will not be said to be a penalty proceeding. But even in spite of that, even if I, my lord, take it for the sake of argument, penalty proceeding is criminal proceeding. Grant of benefit under the MACP shall be subject to the rule governing normal promotion. My lord, may I take your lordship to the rule of normal promotion? My lord, reserving my right, my lord, by saying that penalty proceeding will not be a criminal proceeding.
Got it. We have
Yes,
got
yes,
it.
yes.
So
But,
first is, what is the purport of using expression penalty proceeding? If we have understood correctly, you want to argue that only if it has caused a loss to the employer, it can be said to be a penalty.
Great with your lordship. My lord, if I just hand up to your lordship, my lord, this memorandum, my lord, I just could found out, which is, my lord, issued after the judgment of the Janki Ram's case.
That's
Janki Ramas.
We were going to ask you, that clearly says date of charge sheet and date of charge memo.
That is that one. I was, my lord, preparing myself.
Yes.
I'm so sorry, my lord. So, my lord, about the date of charge sheet, my lord, I just take your lordship, my lord. I have stated in my writ petition that date of charge sheet, my lord, that your lordship will see.
Yes. KV Janki Raman is the case 83.
My lord, KV Janki Raman
93. don't know. I always confuse.
1991.
I always confuse with the citations.
1991. I just request your Lordship, my lord, kindly sees page number 9 in my writ petition. But that paragraph, my lord, starts from page number 8, paragraph number 14, my lord, second page in page number 9. The date of issuance of the charge sheet, my lord, I say is 15th of May 2012. And if I request your Lordship, my lord, the date of consideration of my MACP application. My lord, your Lordship will find page number 49 once. But here your Lordship will see the date is it is written in the my lord, above fourth line from top, which is 19th April 2012. And my name, my lord, is serial number 2.
You told us 1904, it is 1905.
My lord, 19th April 2012.
Oh, fourth line.
My lord, yes. Page number 49, my lord, is C.
Yes, annexure A3.
Yes, my lord, Indian such and such, gun shell factory such and such, Thursday, 19th April 2012. And my lord, the next page contains 2nd of May 2012. The next page. There are 2 dates.
Yes, when do you want it?
As per your lordship's convenience.
You tell us.
The এই দুটো রেখে দিন, রেকর্ডে রেখে দিন। Great. और कुछ
My lord, I am late by Sarojit Ghosh. Lord, I pray for a adjournment.
As prayed, list after. Instead of 93 to.
Any.
Yes, my lord. 89 for the petitioner, my lord. What is your last talk?
There is a confusion regarding pitching issue.
The case for interest on delay on my lord, the gratuity interest on delay, my lord. Page number.
You have seen the last order.
Last order, my lord. Your lordship was for the that. In the railway board's order, my lord, it is said the representation has been made, my lord. And your lordship has made a query that whether any representation has been made against the inquiry report, my lord. It was made.
Have you seen the court's last order? Again, we are asking.
last order
Last. Speaking order.
Our last order dated 5/2/2025 passed by this court. Have you gone through it?
Yes, my lord. Representation had been made. Last order last order last order name. No, last order. Page number 11, it has been stated, whatever the requirement as emailed, that representation by data, you are asked whether any representation has been made. That was the query of the court, my lord. Page number 11, it is here, my lord. Representation by is later dated 7/4/2016, my lord.
For the fourth time, we are asking you,
Yes.
have you seen the court's last order?
Last order, there is a last order.
You are Mr. Ghosh.
Yes.
So you were appearing on the last day.
Last day I was there.
So you are not concerned with the order passed on the last day.
No, I know that only the representation has been made against the same, against the inquiry report, my lord. And that is mentioned in the page number 11. It is mentioned in page number 11, my lord. The railway board's order, my lord.
Have you gone through the order dated 5/2/2025 passed by this bench?
For the earlier order before the supplementary.
Dated 5/2/2025.
Yes, my lord. Oh, no, speaking order, no, order to this. Main petition. Last order, main petition to main. Bobby 2000 কি হয়েছে অর্ডারটা কি ছিল এই যখন হ্যাঁ অর্ডারটা কি ছিল
लास्ट ऑर्डर किस नहीं तो कल की कर जाना हाँ तो जाएंगे बोलो नहीं चलो না না এই তো এইটা আর কি। এটা তো ছিল মাইলো লাস্ট অর্ডার মাইলো হোয়াট ইজ দি অর্ডার মাইলো অন হুইচ দি স্পিকিং অর্ডার হ্যাজ বিন পেন কোনটা বলি কয় ধরনের দেখছি yes 5/2/2025 my lord
Yes.
yes I have got it
Please read it.
yes the learned counsel for the petition is submitting that there has been delay on the 5 years between the submission of his defense and with the response to the inquiry report and passing the final order by the disciplinary authority, for which he need to be compensated in terms of the interest. The on repeated queries he made over the last 2 minutes has been pleased to point out the days and the inquiry report has been briefed the file him. In fact, that is the variation of the page number. That is already the resignation of the brief. Also, my lord, the learned counsel for the petitioner submit that will be placing the records on the order passed by the disciplinary authority so that he saw the there has been that is speaking order of the relay board passed, my lord. That is. And we find that the view of the inconsistency, the brief supplied by the court on the that has also been clarified by the filing supplementary affidavit, my lord. In view of the above circumstances, yes, there is some cost to impose the petitioner and the petitioner opportunity to place the record of the disciplinary authority. Disciplinary authority that has been placed, my lord. Page number 10.
When you have filed a supplementary affidavit? You have filed it already?
File, yes. Yes, ma'am. For
Already filed.
You have
already
served-
filed.
You have served a copy.
Yes. That has been closed, my
You have
lord.
been served.
Maybe I don't know, your lordship, because
Don't know.
Earlier filed.
senior counsel is absent today for his illness. That's why.
Thereafter the matter came up for hearing. দিয়েছি তো।
আমারটা দেখ, তাই দিয়েছো তাহলে ওনার কাছে আছে।
Thereafter the matter has been heard, my lord.
Is prayed by the learned.
Next week. দিয়েছি তো এটা। Date কিতে দেবেন? Yes. Date দিচ্ছি। 19.
Then I am for the response.
My lord, I am for the petition last occasion, my lord directed them to file the affidavit in opposition, my lord.
May I submit?
Yes.
কপি দিয়েছো দিদি?
নাম্বার পাইনি, আর ওই দিয়ে দিদি ধরেনি, দিদির নাম্বার যে দিয়েছিল সেটা
ও
ধরেনি।
আচ্ছা আচ্ছা,
এটা একটু
থ্যাংক ইউ। Yes, sir. Yes. And today, my lord, they are filing, they also have a copy. Tribunal.
Did you file opposition before the tribunal?
Yes, my lord. And my lord, kindly peruse the last order of my lord, my lord.
No, but why the tribunal's opposition was this voluminous?
Yes, my lord, because I have to bring, my lord, they have not annexed the, my lord, all documents. That is why, my lord, I have to bring all the documents, including the reply and rejoinder before the tribunal, my lord.
Then, my lord, if you
I have annexed the reply, rejoinder, everything.
You have served?
my lord, I have
Today I
fixed
have
a date, my.
Six, 3 weeks.
20. My lord.
Mr. Ujjwal Rai, my lord, is appearing on behalf of the appellant, my lord. My lord, he's only at Kotum number 11, my lord. He was waiting, my lord, a matter was taken up. I was praying for not
You
this,
start.
not in possession of any instructions, my lord. Kindly, my lord, accommodates me, my lord.
So he will come. Why don't you start? Let him come.
Matter probably.
My lord, in the meantime, I can do.
What was
For the petitioner.
Petitioners already done and obtained an order earlier. Let him start then.
You are for the railways.
My lord.
When the quarter was vacated,
Not in possession of any instructions, my lord. I was paying for accommodations, my lord.
when the quarter was vacated,
It was vacated on on 20th of June 2029. 19, my lord. 20th of June 2019.
so recovery is for which period?
My lord, recovery is from 2/11/15 till 20th of June 2019. That is the unauthorized occupation, my lord.
2/11/15.
June? No.
2/11/15 is that when the 2-year period has lapsed.
No.
Yes,
November,
because
2nd November 2015.
that's what we are saying. 2/11/15 means 2nd November 15.
My lord, it was June that your lordship said.
No, no, 2/11/15.
Yes, certainly.
So 2/11/15 is that is the date on which 2 years has lapsed.
That's correct.
So she was allowed to occupy for 2 years.
Absolutely, my lord.
So you are saying that from that date you are charging till which date?
Till the date of vacation, my lord.
Can you please repeat that?
My lord, it was 20th of June 2019. My lord.
Son has been appointed on a permanent basis.
He was his son, yes, my lord.
No, initially it was not permanent.
No, my lord, actually.
Initially it was trainee skilled.
My lord, he was initially,
Grade 3.
yes, my lord. Certainly, my lord, the fact is that, my lord.
When he was made permanent?
My lord, he was made permanent on in 2017, my lord.
Yes, in 2017, and he was given the appointment in 2015.
My lord, he failed. Initially, he failed. My lord, in your lordship's previous order, my lord, it was there that it was our fault that he was appointed on 2017, but it was not the fact, my lord. He appeared, he failed, he then again reappeared, and then he passed, and then he was absorbed, my lord. On 22nd of 8, 2015, he availed another chance, as he could not succeed in the first chance, my lord.
No, no, on 22nd August 15, he was appointed as trainee skilled.
Yes, yes, he was initially they are supposed to be absorbed as trainee, and thereafter completion of trainee, they are absorbed as an permanent.
So he has been absorbed on?
He has been absorbed on, my lord. Kindly give me, allow me, my lord. Page 46, my lord, of the writ petition, my lord. Page 46, my lord.
22,815.
My lord.
He is at serial 2.
Yes, my lord.
Okay.
They have to undergo 3 years training.
Group C
My lord.
in pay band 1. Hmm? Did not roll it. 26.
My lord, the petitioner relied upon a judgment of this court, my lord. Perhaps he has not submitted the real proposition of law, my lord.
Yes, which judgment?
This court, my lord, in Lallan Thakur, my lord, upheld, my lord, that the railway authorities can certainly deduct the DCRG, my death cum retirement benefits from the gratuity, my lord. The division bench of this court only, my lord. In Lallan Thakur's case, my lord, as well as he has relied on some other case.
No, deduction can only be in accordance with the act and rules.
My lord. And as far as ours is concerned, my lord, the railway followed well-established rule and board circulars to recover the damage rent from DCRG and is legally sanctioned, my lord, and undisputed, my lord. As far as our rules are concerned, my lord, we are. And second thing is, my lord, that
So recovering a rent under the rules from DCRG is permissible.
my lord, I am relying upon our rules, my lord.
Which provision?
My lord, that is not here. Rule 16, sub-rule 8, my lord. A Now, looking at the copy, you take your copy.
Probably you are relying on note 8C.
My lord,
Note 8C to Rule 16.
my lord.
That is the only provision which takes into
My lord, my lord.
contemplation death of the.
In case of death. My lord, we long back on 2016, my lord, we sent a letter. Apart from saying it verbally, my lord, we gave a letter to the petitioner that kindly vacate this. Otherwise, the panel action will be taken. Despite of serving several notices, my lord, she didn't vacated the quarters, my lord.
You rejected her request for retaining it in November 2017.
Only when she wrote a letter to us. But before that, man, it's there in our writ petition, my lord. Kindly come to page.
Plus, what is the amount payable to her as gratuity? Total amount?
My lord, my lord, calculation is there as far as rent is concerned, damage rents and all that are concerned. The total amount, I am not aware of, my lord.
No, because this, you are relying on this rule.
My lord.
This, whatever it is not a rule. What is this? You are relying upon this document. What is it?
Which document, my lord?
This document that you have given us. What is this?
Well, it's a railway rules, my lord.
Railway rules.
Railway pension rules, my lord. Railway Service Pension Rules 1993.
Railway Service Pension Rules.
Oh, my lord. 1993.
What is the total gratuity due to her?
That I am not aware of, my lord. Your lordships may pass an order for filing an affidavit in opposition, my lord. But if your lordship, then I can continue, my lord. Kindly come to page 117, my lord.
You see why we are asking you this question. Please read 16.5.
My lord. Take it out, put it down.
Whatever may be the dues, you can withhold only up to 10% of gratuity. So you want to recover 14 lakh and odd rupees.
My lord, it's license fee, my lord. License fee, damage rents are different, my lord. In rule 16.5, they are talking about the license fee, my lord. Prior to retirement, 8 months prior to retirement, my lord, whatever the rent is being paid, that is called license fee, my lord. And that license fee they have to pay. And for that purpose only, my lord, this 16.5 is there. But as far as the damage rents are all are concerned, my lord, damages comes into play only when it becomes unauthorized. And unauthorized occupation starts from the day when railway refuses to allow him to stay there. So after retirement, after allowing them to retain their permissible limit, thereafter the clause of damage rents and all that comes. And the fact is, my lord, that if such type of occupations are...
So if what you are saying is to be accepted, you can withhold the entire gratuity.
Who? My lord, if the damage rent says so, we can.
So this rule will prevail over the Payment of Gratuity Act.
My lord. This is what the Supreme Court also says, my lord.
Show us.
My lord. My lord, these are the judgments of our High Court, my lord.
No, you said Supreme Court
My
has held. Show us the
Supreme Court judgment was
Show us.
my lord.
Show us.
I'm sorry, my lord. I am not accompanied by my juniors, my lord. Therefore, I'm taking time. My lord. No. नहीं ना भाई तुम्हारा कॉपी नहीं है सच्चे जूनियर नहीं एका एका बहुत अच्छी बोलो your copy. My lord, the relevant page is, my lord, page 253, my lord. The last para. May I read, my lord?
Just wait.
Para 17, my lord. अकेले मां कोई सपोर्ट कुछ नहीं My lord, I am relying on para 17, my lord, the last para, my lord. ऐसा लगा लेकिन क्या बताएं बहुत बुरा
Yes.
My lord, I am relying on para 17, my lord, the last one, the last, my lord, page 253 of the judgment, my lord. In the present case, admittedly, the respondent retired after office hour, such and such, according to the commission, he could be allowed 4 months' time to occupy the quarters which was granted to him. His prayer for extension was considered and rejected, my lord. In our case also, the prayer for extension was given, granted, we accepted that. To accept the prayer in view of several officers waiting for quarters. He was also informed that if he would not vacate the quarters, penal rent, as per the policy of commission, would be recovered from him. But the respondent did not vacate the quarters. It was only after eviction proceedings were initiated that he vacated the quarters on such and such day. In our case also, we started eviction proceedings, and thereafter the petitioner choose to vacate the quarters, my lord. In the circumstances, in our opinion, it cannot be said that the action of the commission was arbitrarily unlawful or unreasonable. It also cannot be said that commission had no right to withhold gratuity by deducting the amount which is found due to the commissions and payable by the respondent toward penal charges for unauthorized occupation of the quarters for the period of such and such. My lord, this judgment was also relied by our court as well as Madhya Pradesh court in similar cases, my lord. I am placing those judgments, my lord. Very short shots.
Whether you place that judgment or not, it is not relevant. This is binding on us anyway.
My lord,
whether High Court has followed or
trying to do my level best, my lord. After so many odds, my lord, the client doesn't meet us. They don't pick up our phones. No juniors. I am doing it all alone.
Give us this court's judgment. Why do you want to rely on this? Give us the Calcutta High Court judgment.
Calcutta, my lord. Just one line, my lord. Then I will give that. My lord, the second para, last 4 lines, my lord. The tribunal, after relying on the judgment of the Supreme Court in the case of Regional Director ONGC versus ASIR, has found that on account of overstaying in a government accommodations after the due date of allotment, the government is entitled to recover the damages and penal rents, and the amount can be deducted from the pensionary benefits, and rejected the claim. In doing so, the tribunal has not committed any error, my lord. Now, my lord, our High Court judgment, my lord. My lord, the relevant pages starts from page 42, my lord. The Supreme Court's observations. And thereafter, my lord, the observation of our Honorable Division Bench, my lord. May I read, my lord? Having heard the learned counsel for the parties, my lord, page number 42, my lord. Having heard the learned counsel for the parties, in our opinion, the appeals deserve to be allowed. It is no doubt true that pensionary benefits such as gratuity cannot be said to be bounty. Ordinarily, therefore, payment of benefit of gratuity cannot be withheld by an employer. In the instant case, however, it is a specific case of the Commission that the Commission is having a statutory status. In exercise of statutory powers under section such and such, the regulation known as Oil and Natural Gas Commissions, such and such, have been framed by the Commission.
You are reading the Supreme Court judgment. You have already seen it. Why you are reading again?
Then, all right, my lord, come to page, my lord, 44, my lord, para 51, my lord. The concluding order, my lord. As has been held herein before, in the instant case, the railway authorities assess the damage rent in terms of circulars issued by the authorities from time to time with regard to the rate of rents and damage rent and acted in accordance with the specific rules of 1993. My lord, 1993 rules, my lord, the railway pensions, my lord, it has been there also. The writ petitioner private appellant was provided with the ample opportunities of hearing. The authorities then came to decide the quantum and manner of realization, which also was communicated to him in due course. We therefore find no fault in assessment and realizations of dues on account of unauthorized occupations of railway quarters from the gratuity payable to the private appellant. Such order for realizations of damage rent is based on well-defined statutory rules. In the light of the discussions made herein before, we find no merit in the appeal filed on behalf of the private appellant, writ petitioner, being such and such. So far as the appeal filed on behalf of Union of India, such and such is concerned, the same is allowed. We do hereby affirm the judgment and order of the London single judge in so far as it relates to finding negating the plea of private appellant, writ petitioner for setting aside the order of authorities passed in November such and such. However, the impugned order directing release of gratuity to the writ petitioner is hereby set aside. The due amount of damage rent can be realized either from the pension or gratuity. My lord, my respectful submission is, my lord, that the quarters of the railways are certainly public ownership, my lord. And preserving public ownership and revenue, allowing unauthorized occupations to continue without penal rent sets a dangerous precedent. The railway must not be rendered helplessness in securing public assets, my lord.
Yes.
And the my lord, one more humble, my lord, it was never brought in the record, my lord, that she has already waived her right, my lord. As far as the brief given to me, my lord, it's not brought on the record, my lord. I just want to place it before lordship, just to kindly have a glimpse of it, my lord. My lord, it's not placed officially, my lord. They have given me.
What is it? What is it?
Actually, it's a consent letter given by the petitioner.
Whatever is not on record, we are not going to look.
My lord, it can be bought only by way of affidavit.
We don't know. You have filed a reply in the tribunal.
No.
No.
Lordship has never permitted us to file a reply, my lord.
In the tribunal, sir. Why here?
My lord, my lord, my lord. Certainly.
Why here?
Certainly, my lord.
If you have not filed, then we can understand. When you have filed, then your case, the tribunal's order has to be considered on the basis of pleadings before the tribunal.
Yes, my lord. This is not an appellate authority. It's a 226, my lord. Certainly.
So if that is all, he will make his submission after the recess.
Lordship, may I permit to mention, Lordship, it is very urgency, Lordship. Lordship, the matter was heard on 4th August of 25. The Lordship server copy order is not available in the website, Lordship. Grateful, Lordship.
UPA matter item number 47.
Your Lordship wanted me to give the translated version. I've saved copy earlier. Your Lordship was looking at Annexure P8, page 24.
Twenty-four is of which date?
It is at page.
What is the date of this document?
Yes, page 24, my Lord, Your Lordship.
What is the date?
Date is
17th June
17th of June 2022. We know that having lost your dear one, you have been in serious. This is by the Chief Minister, addressed to Fulmuniswaran, the mother of the petitioner mother who died in Karsaneva. We know that having lost your dear one, you have been in serious distress, and you applied for a service to the government and have been waiting for the same. You shall be glad to know that government have very sympathetically considered your appeal and decided to engage you in the Department of Home and Heal Affairs. Hope our endeavors will keep you, your family in financial security. Remember, our government is always with the need of our people and always stood by their side and will so remain in future. This is the Chief Minister writing to Pulmoni Soren, and wife of late Manjura Soren. This late Manjura Soren was a constable who died in harness. And the son at the time was minor. Therefore, Pulmoni herself the widow applied for. It was considered. But unfortunate thing is, my lord, when before she joined, she succumbed. She died in Kanserama. Therefore, your lordship kindly goes to the next application was made to the Joint Commissioner by the son, Arjun Kumar Soren, the petitioner before your lordship. To the Joint Commissioner, Kolkata Police Headquarters. Application for service in compassionate group. My humble prayer to you that I am Arjun Kumar Soren, son of late Manjura Soren, mother late Pulmoni Soren, village so-and-so, a permanent resident. Sir, pursuant to your appointment letter being number so-and-so, my mother was to join in Group D post. But as she was suffering from cancer, she could not. And on last 20th July 22, she died. In these circumstances, pursuant to the said letter, dated so-and-so, if I may be treated as a substitute in the post of a constable, in which case it shall be very helpful. This was the thing. Now, this appeal was rejected. This appeal was rejected by the commissioner against which, my lord, the application was made before the state tribunal.
Where is the rejection order?
Yes. The impugned order, my lord, is the tribunal's order.
No, the order of the commissioner rejecting is there.
Pardon, madam?
The commissioner's order rejecting is
Commissioner's order.
No, the government, page 28.
Page 28. बोले दो. Page 28. Prayer for transfer of the offer of appointment in favor of Arjun Kumar Soren. In enclosing the copy of prayer and reminder under reference of the subject noted above, I am directed to state that the prayer of the above noted subject was taken and examined in this document light of notification number 251 so and so, read with subsequent amendment from time to time, and the case records. The department issued approval compassionate appointment to Fulmoni Soren, wife of late Manjula Soren, in the event of death in harness of late Manjula Soren. Subsequently, DOC officer in charge CP Kolkata communicated with Soren by later dated transfer for verification of testimonials prior to the issue of appointment letter. But Fulmoni Soren did not communicate with the said office of a serious illness. Should I go and proceed?
Yes, we are.
Serious illness and unfortunately she expired on 20th July. As per copy of death certificate submitted by Arjun Kumar Soren. However, prayer for transfer of the offer appointment in instance cannot be considered in terms of clause 12b of notification number 251 so and so. Accordingly, I am directed to state that the government regrets its inability to consider this case for appointment under the exempted category in the light of guidelines contained in notification number so and so. This was the letter, my lord, that was challenged before the tribunal. The learned tribunal made the order, final order of the tribunal. My lord, page 33 starts the order of the learned tribunal. My lord, earlier, I have drawn your lordship's kind attention, my lord, to three particular important legal aspects of the order of this learned tribunal. Your lordship will kindly see this is an order. It is an order by a single member of the tribunal. Present, your lordship sees page 34 on top, present. The Honorable Syed Ahmad Baba, officiating chairperson and member administrative. He is an administrative member. An administrative member, he is sitting as officiating chairperson and delivering a judgment upon his application. My first submission before your lordship whether he is at all competent. He was at all competent or not. But in my respectful submission, my lord, he is an administrative member. My lord, division bench judgment of this honorable court. This is reported in 2012 for Calcutta High Court Notes 320. 2012 within bracket 4 Calcutta High Court Notes, Calcutta, page 320. A division bench judgment by Honorable Justice Shubhra Komal Mukherjee and Nishita Maitre. I'll give a copy of this. I'll give a copy. But it is just only to make a reference. In the concluding part of this judgment, the learned tribunal, the division bench holds. Therefore, In the absence of fulfillment of the requirements as provided under subsection 6 of section 5 of the said Act 1985, the chairman or any other member of West Bengal Administration is not competent to function as a bench consisting of a single member and he exercise jurisdiction powers and authority of the tribunal. A judicial member must be there. And he is admittedly not a judicial member. He is an administrative member. Therefore, it is a clear-cut violation of the division bench order of this honorable court. Next. Next, my lord. Next, I dictate this judgment, my lord. The matter is taken up by the single bench pursuant to the order of notification. Who issues this notification? A chairman is appointed by a judicial member is appointed as a chairman of the tribunal. And the appointing authority is the President of India. How come that you are assuming an office as a chairman? It is a single member. And my lord, lastly, it has been decided that when a single member is functioning, it actually is no tribunal. And in that case, the tribunal has no authority even. So the Supreme Court, my lord, lastly decided that in that case, the tribunal is a defunct and a defunct tribunal. But these apart from all other things, my lord, apart from, I'm not making much serious point, but although these are the points for your lordship's kind consideration. On consent of the learned tribunal councils, on consent of the learned councils for the contesting parties, the matter is taken up for consideration sitting simply. I have drawn your lordship's kind attention to recording of for the applicant, Mr. G.P. Banerjee, a learned advocate. But it is on oath, my lord, affidavit made by the petitioner. I have never given any wakalatnama to this gentleman to appear on my behalf. If someone, a stranger, giving a consent that all that you take up this matter, and by consent of the parties, the contesting parties, the matter is taken up for consideration sitting singly. Supposing that there was an authority given to Mr. G.P. Banerjee, but upon this sitting singly, can you take it up? But not only on this matter, my lord, there are a number of matters it is happening. But that apart, my lord, in so far as my case is concerned, I will be very short. Lordship kindly goes to page 35. That means the second part of the judgment, the concluding part. The concluding part, your Lordship kindly goes. Lordship, towards the middle, the cited clause of notification 251, employed and so. An appointment offered made on compassionate ground cannot be transferred. That you got it. Page. Yes. What is the second page of the order of the tribunal? Second page of the order of the tribunal. Have you got it?
Yes.
Well, it is just the line is starting before the italics. The cited clause notification. The cited clause of notification 251 MP so and so is as under. An appointment offered made on compassionate ground cannot be transferred to any other person. I am laying emphasis upon these particular words, my lord, to any other person. And any such request shall be rejected. I am on a very short canvas. I'm on a very short canvas of my petition. Well, the notification is there. Notification copy আছে? Yes. With the opposition, my learned friend has annexed. Page কত? Yes, page 8. Page 8. My lord, your lordship will kindly see the first day will be. Will be is at page 13. Will be. Request for change in the post. It is 12B. An appointment offered made on compassionate ground cannot be transferred to any other person. Lordship found it? Now. Therefore, the scheme contemplates a transfer, but it prohibits. The scheme contemplates a transfer. It can be transferred, but prohibition is to any other person. My question before your lordship is as to whether this son, a dependent son, is an any other person. Now your lordship kindly goes to page 8. Page 8. Page 8, clause 3. Page 8, clause 3 of that notification. In the affidavit in novel.
Page 8, yes.
Yes, page 8. Three. Dependent family member means B. Son, including legally adopted son before death or in Kappa-Keel societies. Therefore, a son, I am beseeching your lordship kindly consider as to whether a son can be treated as any other person and that he is prohibited under clause 12B. Considering the entire complex of this compassionate appointment that was given, that appointment given to the mother, she could not join because she died. So in that predicament, my lord, the son said that, well, me can be treated, I myself can be treated as a substitute. It is unto your lordship to decide as to whether the order that has been made in pursuance with the order of this notification. My respectful submission, my lord, it is totally misdirected order. A totally misguided and misdirected order in the total complex of the entire institution.
So far as the allegation about Mr. G.P. Banerjee, I cannot make any submission because whether G.P. Banerjee was authorized or not, because I was not there, my client was also there. And so far as single member is concerned, kindly see section 5, subsection 6, notification which has been issued by the kindly see that is taken up on page 34. You got it?
Page 34 of the writ petition.
The in order. The matter is taken up by the single bench pursuant to the order containing notification number 638 dated 23rd November issued in exercise of power conferred under subsection 5 subsection 6 administrator. Can you see subsection
No,
5?
so he has said it is not a very serious point, but he has.
Yes.
You let us proceed on.
Judgment of the Honorable Division Bench, presided by Justice Subhakumar Mukherjee, Justice Nishita Matre. They say, but at that point of time, there was no such notification. That's why that doesn't. I mean, so far as apart, kindly see the language used in notification dated.
If the petitioner applicant had a serious objection, he would not have before the tribunal. He could have raised this objection.
He could have wait for order constitutional.
So, what is the submission on the merits regarding? Yes.
The merit for that application was made by the wife, but according to clause 3, but kindly see clause 3 of the notification dated 3rd November 2003. Definition: dependent family member means spouse or son. Spouse applied. Her case was considered and issued appointment letter offer, but she did not turn. In the meantime,
she could not turn up.
Not turn up.
Did not and could not are two different.
Could not turn up.
Yes.
Because of unfortunate injury.
Obviously, she was on the deathbed because within few days thereafter, few weeks, 1 or 2 weeks.
Informed that I'm suffering from this disease.
That is a different thing. But at that juncture, whether one will think of giving an intimation when one is in dire straits, just recovering from the death of the breadwinner, and then she is on the deathbed. So those things are different.
But the government said that there was no communication for the.
Obviously, that they are not saying they have communicated.
Yeah.
They are also not saying they have communicated.
There is no communication from the family that the lady is unable or is not suffering from cancer or whatever may be the disease. It was there. Then the government only that in place of herself, it should be transferred, offered to nominated party.
Where is that?
That page. Page 28. Yes, that was
No. Where has she said that it should be transferred? Page, please. Page 23. So this is what you have responded to. That no, we are asking you the 30th August is in response to this application. No, it is dealing with this application or it is dealing with some other application. How can I reminder? 11th and 16th, not 18th and 16th. So this what you have, that is why we asked you, this is not the application being considered by you. Page 23, what you are showing us is not the application considered by you. That's why we asked you, where is it? You are considering a different application, an application made on 11/8 after demise of that applicant of page 23. Where is 11.8 and 16.8? Anyway, even if it is not there, it is not in dispute that the son has requested that he should be offered.
It should be considered.
And that is what is considered in this 30 August 22 order. So there is no request for transfer by the beneficiary. It's not a case of the person who has got the benefit that he is or she is asking you, please transfer it. That's not a case. It's not a case of transfer. Whether family, other person, that of course is an issue, but whether this is a case of transfer, a transfer would be only when both are alive. That instead of me, you give it to him.
No, but transferring, if somebody is offered appointment, he does not want to work there.
So therefore, this is not a case of transfer.
No,
Our prima facie view is 12B will have no application. It could have had an application if both persons were alive. I have got a benefit and I say, no, instead of me, he is also part of the family, you give it to him. Perhaps that 12B would not be allowing, maybe. But that's not the case here. The case is the person who was offered could not avail the benefit because of reasons which are not in dispute.
Admitted fact.
Admitted fact. Now, in this circumstance, the concept of compassionate appointment is to provide succor to the family. Family is the unit, not that individual.
No, family, when a family has been
Correct means dependents. It is for the benefit of defendants. It may go through one or the other of the family members. So the person who is to provide the succor, if he all of a sudden he vanishes for such a reason, the family should be deprived. Is it the case of the state? Then
what can is the language?
That's a different thing. That does not arise here. That does not arise. 12B is what is in issue. 12B says even if offered, it does not say appointed. It says offered or appointed. It can
offered.
Yes, we have seen that. Even if it is offered, what is the prohibition? Even if it is offered, it cannot be transferred.
Transferred means in place of X.
That is not the case. That's not the case. Nobody wants to take in place of someone. That person is no more there.
Unfortunate.
Then for such a circumstance, how 12B can be relied upon? This is not a circumstance in our view covered by 12B. 12B could have been relied upon if it was a case that now I am feeling very weak, I can't do it, please give it to my son. Then maybe 12B, we don't know, that's not the case according to us prima facie. So the unit has to be deprived of the benefit of your scheme because the person who is the intermediary to provide the succor to the family for unfortunate reason is not alive anymore.
Transferred.
What is the date of offer? June, perhaps, sometime in June. So there is an additional fact, his lordship is correct. In May, she has told you that, look, I am down with this kind of a disease, I may not be able to. So before the offer, she has informed you. You please see annexure P7. She told you that, look, this is the unfortunate circumstance, I may not be able to in a condition to.
Both sons are his father-in-law is governor on duty. We got to continue the education of my son.
So the issue is, what is a transfer? Why 12B will apply? What is a transfer?
Because
Transfer can be between two persons. There has to be two persons for a transfer. Any kind of transfer, it has to be, there has to be two points in existence before a transfer can take place. Whether it is from one post to the other or from one person to another. 2 points have to be in existence. There is this, the other point is not here. Yes.
Yes, my lord, I beseech your lordship's observation. That means there should be two living individuals.
Otherwise, how a transfer? Whether any other person or within family comes thereafter.
There should be two living individuals.
So how 12B will apply?
At the date, was what is that? That will not be a transfer.
That is what the court says. Yes.
Into legal sense.
Enough, please.
You have any, we have any dictionary in the court? Dictionary है क्या? Black's law या law lexicon कोई नहीं? Ramnath Ayer's law lexicon, Ramnath Ayer's law lexicon. Can we keep, we'll keep it for orders on Monday. Let us go through the dictionary meaning of transfer. I would like to deal with that because 12B application has to be seen. We are keeping it under orders. If you want on that day to show something, it is
on Monday. Hearing concluded. Hearing concluded.
Yes. Why you are smart? Yes.
Mr. Ali.
For 21.
Just let us get the file.
The last occasion, there is a direction to file opposition, Lordship. This is my opposition.
You are serving a copy right now.
No, I have already served the copy of the opposition, Lordship.
You want to reply?
Well, I have also replied that one.
You have replied.
Rejoinder also will submit it. Oh, already.
When did you submit the reply?
But this is immediately after the reply. I have submitted the rejoinders. The rejoinder. The limit of service. Both service. अलग करो. अलग करो.
No, there is no reply on record.
Lordship,
When did you file it?
Lordship, I have not received any copy of reply, Lordship.
Yes, there is nothing here also.
But that may be, sorry for that. There may be some gap. Let me give me time. I shall be in a position to supply that on copy.
Opposition filed by the
Lordship, I am for the respondent for Union of India.
देखो देवदत्त देवदत्त
who is appearing in 22.
Lordship, I am for the respondents, Union of India. We are challenging the writ petition for the illegitimate wife. He is asking for the pension of the deceased person. Lordship, the persons who was in the government job who has died on 26/1/28 and 18, and after that the marriage certificate is issued.
There is none to represent the petitioner. The learned advocate.
Item 23. Sorry, 24. Item 24.
My lord, item number 24, my lord. On behalf of the petitioner due to illness, I am praying for not this week, my lord. To our telephone, he told me, my lord. Petitioner, my lord. Advocate on record.
You are filing something.
The opposition.
Give a copy.
Already served long back. Already, sir.
Position being filed.
Really?
Five.
I like advocate on the court and senior counsel, Mr. Fodik Chandra Das. He is out of Calcutta, my lord.
Lord, I am for the petitioner. My lord, contempt
just-
proceedings is in the lower floor. My lord, kindly stay the contempt proceedings, my lord. There only.
No, there is already an undertaking recorded by them.
Contempt, my lord, this is kindly stay the contempt.
Already they have stated we have recorded in the order that during pendency they will seek adjournment of the matters. What is the problem? They have already said that you have jointly seek an adjournment on the next in the pending contempt before the tribunal in view of pendency of the matter before this court.
Yes.
You have to seek adjournment. If you are seeking a time, then how much time do you want?
My lord, 2 weeks.
No, my lord, not 2 weeks, my lord. Only. My
What
lord,
is the next date?
next date is 26, my lord.
26th of?
26/8, my lord.
Please show us the order.
That is December 26 August 2025, my lord. For orders, my lord. My lord, the matter is here, my lord.
Yes. The learned advocate for who is
Kindly grant me 2 minutes time to file.
Learned. We are allowing her time to file a reply, 2 weeks.
Grateful, my lord.
$27.
Yes, give us the file.
Application against the dismissal of a contempt application by the tribe. These the petitioners were electricians and pump operators of the GPO. Now, they were daily rated Mazdoors. They were not being given the benefits, and therefore they made an application before the tribunal, and the tribunal allowed their application. Thereafter, a reasoned order was passed by the authorities, and a contempt in the contempt application. Now, your lordships have already passed an order in similar circumstances, where your lordships have held that since a reasoned order has been passed by the authorities, the petitioners should go and challenge that order before the Learned Tribunal. This was an order passed by your lordships here. That this is the only thing. But your lordships will have to know.
Oh.
The lordships have already passed an order in an earlier application. We are similarly circumstanced.
What is the application pending for?
The application was that now they have been put under contractors.
No, there is a can pending.
Can. So that can be also disposed of, but your lordships have passed an order. It's only that I have to point that out before your lordships. Similar order will may be passed in our case also, so that we can challenge that order before the tribunal.
The petitioner is similarly situated.
Yes, same. They were the same group. Two of them filed a separate application which came up before your lordships, and your lordships were pleased to pass this order. So therefore, I cannot ask for anything else.
Let me have the copy, man. I don't have any copy.
Please share a copy with him so that he knows what you're talking about.
6 and 7, paragraph 6 and 7.
That will go to the order, yes.
It is in his favor, not mine. So,
whatever you rely upon, he has a right to see.
Yes, I have.
They want equal paper, equal.
Paragraph 6 and 7 of your lordship's order.
So this office memorandum is one and the same.
Yes.
22/115.
All of them were the same.
And what is the date of the reasoned order? Same.
Same, it's all the same because of the fact that all of them applied together before the tribunal. Now, two of them preferred a separate application before your lordship, and we are the leftovers. So, we preferred an application here also. But that matter came up before your lordships before this matter, and your lordships have already decided the issue.
The tribunal's finding is recorded in which OA?
Well, it is also in mine. Your Lordship kindly comes to page 67.
The findings referred to in paragraph 3 of this order that you have handed us.
Yes.
That finding is with reference to which proceeding? You please see paragraph 3 of the order that you have given to us.
আমি ভেবেছিলাম যে আপনার কাছে থাকবে, তাই জন্য আমি দেখি।
Paragraph 3 is at page 1 perhaps. First page of the order. The tribunal had
Yeah,
come to.
I'll show your Lordship that. That's at page 128. This is the reasoned order.
No, we are asking you, there is a quotation in paragraph 3 of the order that you have handed us. Please see the first page of the order. Paragraph 3. This tribunal's order dated 22/7/24. Where is this order from which we have quoted in that earlier order? So perhaps this reasoned order is passed in compliance of that order only. Oh.
That is
Okay, so this is the impugned order.
internal page 3.
Paragraph 3.1 or 2.1 of the
2.1.
Okay.
Internal page 3.
Point 1 of the impugned.
Page 3. Internal page 3 দেখুন। একদম লাস্টে যান। Last.
You can just give here the tribunal in incorporate CPA CPA 19 of You have also been allowed the remuneration in terms of 22/115.
Yes, I was allowed, but then that was turned down by the authorities.
And the reasoned order is of 21/2/22, or in this case it is different.
Same order.
Same order.
Same.
26. Please. Everything is same.
Page 132.
So since you'll be raising every issue,
you
we'll
keep
just
that-
the CPA is can be disposed of as
disposed of, that your Lordship disposes of. All points are left open.
Yes, all points left.
Yes.
उसको चेंबर में it's addressed in the chamber. Blacks. Ashwin.
Item 28.
Subsequent dismissed. Subsequent dismissed. Application to dismissed. Yes, on behalf of
Item 29.
Your Lordship, 29 and 30, similar matter of Ministry of Defence is the party. Their appeal, I was praying, let it appear in the monthly list of September. We are not ready with the matter.
My lord, I am in item number 30, my lord. I have been lately engaged by the respondent, my lord. Previously, there was another learned advocate, my lord. I shall also need some time to go through the brief, my lord. In 30, my lord.
you are not appearing in 29.
No, my lord, I am not in 29.
Have you filed the supplementary
Your Lordship, this was fine.
in terms of the court's order? Who is for the respondent?
It's coming after a long time. Probably that's the reason.
No, because there is an interim order. Find out where he is. You inform him.
Your Lordship.
We are adjourning it not today only, tomorrow you inform me. In 30 you take down. In 30 you take down.
Item 31.
No.
Same order. Dismiss.
Item 32.
My Lord, I'm praying for not this week, my Lord. Learned Advocate Kaushik days are pending this matter, my Lord. Due to some medical emergency, he has to go to the hospital, my Lord. His wife is seriously ill and admitted in the hospital. And 34, my Lord. And
Call one by one. It's all time.
For 35.
I'm going to prepare my, I'm taking my 2 weeks time, my.
Why, sir?
My, yes, my, yes.
Huh?
My senior is seriously ill, my lord.
Seriously ill. Why you are not interested in doing the matter? Last day there was no appearance. Today. No, there are already 3 adjournments. Can't be adjourned. Hmm? Then an advocate for
Item 36.
Lordship, in item number 36, Mr. Dheeraj Kumar Trivedi appearing for the Union of India, Lordship. Due to his personal reason, he is out of town, Lordship, praying for not this week.
Mr. Trivedi appears for the respondent.
Respondent, Union of India, Lordship.
Yes, but who is for the petitioner? 6. Same order, none appears. Last day, 11th.
Item 37.
37, Lordship. Respondent number 1.
But I am for the petitioner, my lord. So in this matter, I am led by Mr. Lakshmi Kumar Gupta, my lord, senior advocate. He is not well. He is not coming to court, my lord, for the last 1 week. My lord, can it be, my lord, adjourned for 2 weeks, my lord? 2 weeks. He is seriously ill, my lord. Has prayed on behalf of the respondent. Take the appearance.
Item 38.
Yes, my lord. I am for the petitioner, my lord. Page number 33, my the case is there, my lord. No. Yes, my lord. During the lifetime of the ex-employee, my lord, he has given the declaration before the railway authority that he is married and his two sons is there, my lord, and who was born in 2001, my lord. And when after the death of the ex-employee, my lord, after the death of the when she had applied, she came to know that there is another wife is there. She has also claimed, my lord. At the time of submission of the document, When this all the document has been submitted before the railway authority, thereafter he knows there is another wife. That is the case, my lord. As
So,
per
therefore, tribunal has said you get a succession certificate, you get the money.
the long actually as per master circular, my lord, if there is a declaration has been given by the ex-employee, the railway cannot tell the for succession certificate. That is the rule, my lord. That rule is there.
Yes, let us see.
Okay. Eight, 7, yes, master circular. Yes, my lord. Page number 78, my lord. 78, 78. Eligibility, my lord. Gratuity. Eligibility, my lord. The last point, succession certificate is not to be asked for unless there is no valid nomination and also none of the family member mentioned above is available. So when the family members are available, lordship court.
You are only claiming gratuity.
Yes. No. Yes. No, only no pension. Family pension, my lord. But the gratuity is one of the part, my lord. When there is a declaration is there, is available with the railway, there is no need to success as any advice for any succession certificate, my lord. And now it is proved that the all along the she and her son has got the railway benefits and medical card, pass, and educational assistance also, and all along she has got the benefit. And now she is residing also on the.
Yes.
She is residing also in the flat of the husband left by.
Serve notice.
Yes.
Serve notice.
Now already served, my lord.
You are for
Is second table.
the private respondent. You have not implemented the other person.
Yes, my lord.
Then notice serve on her.
Yes, no, servant already affidavit service has filed, my lord. I have already notice has been given earlier.
You file, you serve.
Then affidavit of service has been given.
Maybe. Let
Again,
service. Have you included all the documents from the tribunal?
Yes. Here reply and the private respondent appeared in the tribunal reply also there. All the records are there. Okay.
Lordship, I am appearing for the petitioner. Here is my affidavit in service. Affidavit service.
My lord, my lord, I am praying for not today. The senior is not here due to some
I have a
personal
humble
difficulty.
prayer, your lordship.
You are representing all respondents
Yes, my lord.
who are Union of India.
Yes, my lord.
I have a humble prayer, your lordship. I have
Yes, what is wrong with the order? Let us see.
Your lordship, at first I want to say one thing, your lordship. I have filed a subsequent CAN application, your lordship, for addition of party.
Let us see what is wrong with the order. If the same relief has been rejected for others, how yours can be entertained? Tell us.
Your lordship, my senior is not present today. So
What senior, sir? These matters, there is nothing here.
please
Not
allow my
today.
CAN application and keep the
No,
matter.
no, not today. What can application? Come tomorrow. Assist us.
Much obliged.
Unnecessary keeping the matter pending when there is nothing. Given us check.
Yeah, we can respondent. One payment letter have to be taken up tomorrow, my lord.
Huh?
Tomorrow morning later. Only one day accommodation I am praying because my lord, for ready myself, I was ready, but today, my lord, there are some other matters.
Order the. Well, submissions, kindly see what submissions are being made before the tribunal. That we have not taken any step to get the matter extended.
Yes, they have not taken steps. Previously, they have not appeared also. They have not taken.
I
steps
appeared
to-
on Saturday.
They have not taken steps to extend the interim order. That's all submission. Only one day time I am praying because today I have some another matters also. have to go through it only once.
This is a matter when here compassionate appointment has been granted with effect from 2003.
There was some manipulation there. And that has been said by the
That
tribunal.
manipulation has been challenged in after more than 20 years perhaps.
No, when they have not appeared, they are appearing on every date. What do you mean?
They are appearing on every
They
day.
have not taken steps for extension of interim order.
So they are taking steps right now.
Well,
Your objection is now not tenable. Now they are taking steps.
We taken up tomorrow morning. That's what I'm saying.
no, because these matters your lordship takes up on
Already there
Thursday.
is an interim order.
Wednesday.
That interim order was applicable till 27th. When is this matter fixed before the tribunal?
26th possibly. It's stated in the order. No, it's stated in the order.
You are the applicant and you don't know.
You are making submission there.
There are some other landed advocates.
You are the applicant for us.
Yes, that is correct. That is correct. Only one night I am paying time.
What is the issue?
It's compassionate appointment with effect from 2003.
Why it was rejected 5 times?
Well, it was rejected, my lord. First, there can, if we actually take what has been stated, the court has held that was illegal. He was in 2003. His father retired in 2000, and 2003 he was in fact recommended for appointment. This was recast, my lord. Recast not because of some mala fide intention, because the whole process of there were only 3 vacancies were made. So this was recast. Recast, other people were considered, and the person who was above him was in fact posted in his place, and he did not have qualification for other posts.
There was a queue
Well,
for compassionate appointment.
and he did not have. He could have got had he had. There were several other. One was printer. There was even the post of driver was left vacant because there were no candidates. But he did not have qualification of driver. So he could not be accommodated. The posts were increased from 3 to 5. But due to bad luck, my lord, he did not get it. He did not challenge it at that point of time, my lord. So repeatedly he was.
That is not correct.
Correct, my lord.
Director five.
He has approached the tribunal. Kindly see, that is not.
Sorry.
He has filed in 2023, my lord. Exactly 20 years. বসে যাও, ওদিকে বসে যাও, নামটা
Take it up in the next.
D, interim order B.
Learned advocate for the respondent.
My lord, next week I will not be available. Tomorrow, my lord, tomorrow I will be.
Tomorrow we will not take it up. Tomorrow we will not take it up.
27th or 25th. Any day as your lordship.
You tell us. Give us an agreed date.
25th.
25th.
27th করো যেদিন সুবিধা হবে 27th
27th হ্যাঁ
my lord agreed
Item 41.
Yes.
Lordship, the respondent was served, but the envelope has come back as घर का के पते पर नहीं था कोई.
Let us see what is the issue. So what is the prejudice there? The tribunal has only asked you to examine his case.
Your Lordship, the tribunal has asked us to.
You did not dispute that he is similarly situated. You are only saying that he has come after 6 years.
Your Lordship.
Now, in matter of salary and pension, it's a continuing cause of action every month. So the tribunal has said you examine his claim. What is wrong with you?
Lordship, but we have stated that there is delay of 6 years, and as such, and the railway board had clarified that in P11 we have annexed the railway board's clarification stating that in each case, whatever Supreme Court had ordered, that would be applicable for that specific case and not for all the cases. Page 128, in the circumstances explained in the Railway's letter referred above, the issue has been examined in this office and it is clarified the judgment of the Honorable Supreme Court in SLP number 25730 of 2009 is only applicable in the case of the concerned petitioner, that is Narayan Ram, and not in any other person. Hence, it is advised that the railway must take a decision at their level in the instant case.
Yes.
For each case, the petitioners have to individually, and the judgment cannot be made, is not in rem, it is in personam. That has been clarified by the railway boards.
How the railway board can clarify whether the judgment is in personam or it
Lordship,
is.
each petitioner has to come up individually.
The judgment can, by going through the judgment, we can appreciate whether it is inter parties or it is judgment in rem. Where is the judgment being relied upon?
Lordship, the judgment of SLP is P10.
P10.
P10 is at page 89, it starts 90 onwards. The relevant portion is at page 113, 113, Your Lordship, para 29.
No, but this judgment has been modified by the High Court.
Your Lordship, that is at page Justice Kalyan Jyoti's order. That is relevant.
What is the significance of the date 1st December 84?
Lordship, that was his date of joining. In this case, the date of he started working as a He was observed on 20th November 2003 over here. For him, the relevant date was 1983 when he started working as a vendor for this petitioner in the SLP. And
No,
page
that petitioner had started working as vendor in 83.
83. And relevant page of Justice Kalyan Jyoti's order, the High Court's order is at page 125, middle paragraph.
What is the date of?
He started over here as a vendor on 23rd November 1972. And as per the seniority, he was observed on 20th November 2003. And
No, this petitioner in WPCT 471, where we don't find that he was absorbed in 83, 84. Is that date available in the tribunal's order?
page 112, para 27, the situation in the case of the applicant in OA is similar in as such they could not render 10 years regular service and therefore was denied pension. If, however, as observed by us, the cutoff date is fixed as 1st December 1983, the date of interlocutory orders passed in T.I. Madhavan case, notwithstanding its modification subsequently as regards payments of salary only, all these applicants shall be eligible to get pension or other benefits as the rules as in that event in their qualifying service would be more than 10 years and the date of retirement. Otherwise also, since the railway in respect of non-statutory recognized canteen employees, thereafter, so
What is the basis of this date? Was December 84.
Supreme Court had given a cutoff date, what I read in page 112.
In some other case, Madhavan
Some
case.
case that we T.I. Madhavan case,
Yes.
they had given a cutoff date that 1st of December 1983. We are giving the cutoff date from which the computation shall be done. Otherwise,
Which page?
Page 112, Your Lordship. Para 27.
No, that was 83. That the High Court has rejected. That they cannot get it from December 83.
High Court stated from 84.
Yes. So from where this 84 has come, that is what we are trying to see.
Your Lordship, may
The
I?
High Court has said that because earlier they were vendors, agents cannot assume an identity of a servant. So the work done as an agent cannot be recognized. But from where this 84 date has come, that is what we are trying to understand. Because the High Court has modified it from 83 to 84. But on going through the judgment, unfortunately, the reason for giving that cutoff date, we are unable to find it.
Your Lordship, page 102, third paragraph. In view of this, we must necessarily modify the direction contained in the court's order dated March 10, 1986 as to the payment of salary. In modification of the earlier direction, we direct that the vendors and bearers so observed in the railway catering services shall be entitled to salary from the date of their observation and not from 1st December 1983. There also a date is coming, but how this is relevant?
So 125 is the, we are of the view that even by the latest, Eastern Railway authorities would have fixed the date for computation of pension from 1st December 84. The court has considered it a reasonable date because policy is of 73, Supreme Court directed to implement in 83. So the court gives you 1 year's time. That if you have not taken any steps, at least till 1 year time is given. But from 1st December 84, you should have done it. Even though these persons who were before the court, they were absorbed much later.
In this case, Your Lordship, he was observed as per his seniority, which we have stated in para 7, that respondent being Arjun Ram was junior to majority of other commission vendors. His screening and posting were conducted after those of his senior registered commission vendors. Consequently, the respondent was absorbed into railway service as Group D staff effective from 20th November 2003.
Those petitioners were also absorbed in 99, much after 84. Therefore, what is the difference? There is no difference. This is WPCT 471.
This WPCT 16.
No, that order has been passed in 471.
Railway Board's order, Your Lordship.
No, the earlier writ petition that we were just reading at page 120.
Your Lordship, 471.
That 15 order, because you see page 127, your board has decided that no SLP is to be filed. So you have accepted this WPCT 471 of 2006. This is after that 6/4/2015 letter that you are showing us. That is a much earlier communication. 16, 17, 18, up to 4 years thereafter you have decided that SLP is not to be filed.
Because in this order, the court stated that earlier the relevant portion as such, we think that the judgment on order of the learned tribunal is quite justified in basis factual aspect, then it cannot certain modification to the such observation. Therefore, service period should be reckoning for the purpose of computation of pension instead in so as reckoning the service rendered prior to itna the capacity of commission vendor agent as directed by learned tribunal is concerned, same cannot.
Which letter you are reading?
Page 125, Your Lordship.
Correct. So prior to the service rendered as commission agent is something else. In that case also, they had not ceased to be commission agents from 1st December 84. They had ceased to be a commission agent from 99 in 471. How this one for December 84 date, from where it has come, it is, we are of the view that even before it can be. Therefore, the tribunal said you take a decision in accordance with the judgment passed in that case. This OA has been filed by him for the first time.
Your Lordship, for the first time. And he superannuated in 28th of February 2013, and representation.
And where are these orders? He is seeking an appropriate direction to rescind or cancel orders of 9/10/19 and 17/10/19. Where are these two orders?
Fourteen 10/2019 is at page 61. Under the RTI, he was given a reply. Page 60, page 59 was
9/10.
9/10. Your application dated 5/8 has been examined and it is furnished, as this office has not received any other order from the Honorable Tribunal as mentioned in your appeal to grant benefit. The same is not acceded to. You are not entitled to pension as per Railway Service Pension Rules 1993.
Actually, what you are asking him to do is that since there is no order in your favor, we will not do it. And in the case of the writ petitioners of 471, when it was finally implemented? This arises out of 350, 1087.
1653 of
No, the 471 arises out of OA number
71 is from
1087.
1087
That's the number.
and in 1181.
No, it arises out of 554 of 99. Only a typographical error. Here it says it has been modified. 454.
OA 545 of 2019 and OA 109 of 2003. 471 had arisen. Page 115, Your Lordship, the cause title bears the.
So if this benefit has been granted to another person also who had approached the court in way of 2015, 1181 of 2015. You see paragraph 8 of the tribunal's order. Only delay of 6 years you are
In his original application, he is not even explained as in the limitation point, page 35. He has just said the applicant further declares that the instant application is well within the period of limitation as prescribed under 21. The applicant craves leave to make further submissions. So he's not even pleaded for why 6 years he could not come. Reasonable, some reasonable.
Where's your reply before the tribunal?
Your Lordship, our reply is at page 62 onwards. 63.
There's no issue of delay because in 19 his representation was rejected. You have also not raised any issue. That is perhaps why, because
In our reply, we had stated that there is a delay, Your Lordship.
no, you say that he has come after 6 years, but the application is not barred by limitation because the representation has been disposed of in 2019 and he has approached the tribunal. You say so in paragraph 7.
Your Lordship, page 67.
Yes. Nowhere you have said that he is in any way different from the applicant of the earlier way.
Paragraph 11, page 69.
11.
Page 69, we have stated that order passed by NITNA is applicable only to the concerned applicant. The applicant never approached this honorable tribunal immediately upon his superannuation, seeking similar relief. So we have stated because he's not similarly situated.
No, that you have not said. You said he didn't come claiming the same relief, he should have come earlier. You don't say.
He is not vigilant because after that we have said.
Vigilance is a different thing. Not being similarly situated is a different thing. That where have you said in your reply that he is not similarly situated as the applicants of the earlier way? There is nothing of that kind. You are only saying that he has come 6 years after retirement. Now, in a relief for a pension, it is a continuous cause of action. Every month the cause of action accrues. We'll pass the order in the In the meantime, if you can find out the rationale for December 84, then let us know when it is.
I'll mention the matter.
Then 42.
Personal again. I'm praying not this week.
Why, sir, every day adjournment?
He has not come today.
Every day?
Personal.
This is the third time, sorry.
According to my physical condition is very bad. Probably I said, let's check his health.
Not today. Ask him to come tomorrow. Not today. You assist. What is this everyday adjournment?
5 matters are there, my lord.
Huh?
Another 4 matters.
Sorry. Why every day you are getting an adjournment? Continuous third day adjournment? If you are not interested, then don't. Why do you file the matter? Yes. It will come, not today.
Same prayer, my lord.
Same order, not today. All these matters.
Item 44.
Your Lordship, I appear for the petitioners.
In 44.
Your Lordship, this is also a disability pension matter, Your Lordship. If this can be kept also together in the monthly list of September.
Yes.
Your Lordship, I'm led by Mr. Vipul Kondalia in this matter. If this also can be kept in the monthly list of September.
On?
The monthly list of September, Your Lordship. This is also a disability pension matter.
As prayed. Same order with as prayed.
Item 45.